The revelations were made in a court filing in California where lawyers for the committee argued that Trump attorney John Eastman should not be allowed to withhold emails under attorney-client privilege. Eastman, you may recall, was the lawyer who tried to provide a legal basis for Trump's efforts to overturn the election. The committee's lawyers argued that Eastman's documents should be reviewed privately by the judge to determine if they fall under the, quote, crime or fraud exception to the attorney-client privilege rule. And in the filing, they revealed that, quote, the evidence provides at minimum a good faith basis for concluding that President Trump has violated Section 18 of the U.S. Code, specifically that he obstructed, influenced or impeded or attempted to obstruct, influence or impede an official proceeding in the United States, and that he did so corruptly. They also say the committee also has a good faith basis for concluding the president and members of his campaign engaged in a criminal conspiracy to defraud the United States. They suspect that a review of the documents may reveal the president and members of his campaign engaged in common law fraud as they tried to overturn the election. I'm joined now by one of the members of the committee investigating January 6th, Congressman Jamie Raskin of Maryland. And Congressman, I'm very pleased to have you specifically because I know in your previous life you were a law professor, and this is almost like a law school final exam. There's a lot going on in this in terms of the filing and in terms of what's happening. So I wonder if you could just sort of explain to us what this is. I mean, let's start with Eastman. What was his role and how is he attempting to fight the committee's subpoenas?
Yes, it's like a law school final exam where the whole fate of democracy is riding on the answer. But look, John Eastman was operating as a freelance legal political operator. He was speaking all over the country at rallies and so on, and he was making the arguments that Donald Trump came to absorb and integrate into his approach, which is that Vice President Mike Pence had the unilateral authority just to quash and nullify electoral college votes. And Eastman was running around saying that the Electoral Count Act was unconstitutional. And under the Constitution, the vice president had heretofore unknown extra constitutional powers to nullify electoral college votes that had been certified from the governors of Arizona, Georgia, and Pennsylvania. So we have demanded to get all of this information and all of these emails from him that he engaged in as part of this campaign against the election. And he has asserted that they're covered by the attorney-client privilege. The problem with that is that there's no evidence that he was acting as the president's attorney or that they had formed an attorney-client relationship. If they had formed one, it had clearly been waived both by the president in telling him to go out and to make all of these arguments and by him in terms of his conduct. But then finally, we say if a court somehow were to find that there was an attorney-client relationship and it had not been waived, then very clearly it is not covered by the attorney-client privilege because of the so-called crime fraud exception, which is that attorneys and clients are not covered from discovery if they are involved in criminal activity. And here we identify at least three different kinds of criminal conspiracy and activity that were afoot. One, conspiracy to obstruct the federal proceeding, the joint session of Congress to count electoral college votes. Two, a conspiracy to defraud the United States by sending in these counterfeit slates of electors and then using that as a pretext for shutting down the proper counting of electors under the 12th Amendment and the Constitution. And third, just common law fraud. So the whole thing was basically an attempt to perpetrate a scam. The president was talking about stopping the steal. He was trying to perpetrate a steal of the election, and John Eastman was very much part of those plans.
You and your colleagues strike me as fairly savvy about all this. You know what you're doing. Yesterday, when this filing was filed, when it became public, it made huge headlines because the committee is saying we have a good faith reason to believe the ex-president engaged in a criminal conspiracy. Is this just an argument that you're using in this filing to sort of, in that kind of lawyerly way, argue in the alternative and try to get these documents? Or should we take this seriously as the current, reflecting the current belief of the committee based on the information that's gathered?
Well, before we even spelled all of this out in our pleadings, Chris, this was raised sua sponte by the judge. The judge himself raised it in the case. And so we, of course, had an obligation to address it. And, you know, the judge reasonably raised the question of whether all of this could be protected by attorney-client privilege when it was meant to pull a fast one and overthrow the presidential election. So we think we just followed through on the judge's invitation. And again, because we've argued sequentially in the alternative, there are lots of ways of deciding it before you get to the crime fraud exception. And of course, this still is within the realm of civil law. It's not a criminal prosecution, but I think it is fairly raised under these circumstances.